Good day. I'm Adele van der Walt. I'm a practicing lawyer specializing in fertility law, surrogacy law, and medical law. We represent clients both nationally and internationally. Today I'm going to discuss the legal pitfalls of surrogacy and fertility law. First of all, I think we should discuss the requirements in terms of legislation to enable a patient to lodge an application for surrogacy and to get such order granted. So first of all, we refer to the parents that want to obtain an order as intended parents. There needs to be a medical reason which is permanent and irreversible for such parents to qualify. So this is important to establish from the treating fertility doctor what the situation is and the history of the patients, especially if we're now referring to heterosexual couples. If it's a same-sex couples, a male couple, obviously they will qualify due to the fact that they don't have a female in the relationship, and for that reason the court will grant such order. It's also important to check, as we've said, with the medical history of the heterosexual couple, the reason why they can't carry their own child. The treating doctor will also then indicate what material will be used. In terms of the Act, it's a requisite that at least one of the two intended parents' material needs to be used. If it's a single person, single male, or a single female, and they opt for surrogacy, their material needs to be used. It's important as well to know that in terms of South African law, it needs to be altruistic. This means that the surrogate must really assist the intended parents out of her goodwill, not as a source of income. So it's possible to compensate the surrogate for real out-of-pocket expenses. But if she has a child of her own, she is, argument's sake, single and financially not stable, it becomes a problem with the court application, and the judge may ask for extra information to convince court that the surrogate mother can sustain herself and that she's not using surrogacy as a source of income. Another requirement that we can also discuss is the traditional surrogacy. So first of all, I would like to explain traditional surrogacy. So in terms of our Act, it's possible that a surrogate can provide her body, that's now a uterus, to carry the child, but that she can also make available her own genetic material, that's her eggs. In terms of traditional surrogacy, it means that it's half her child. She will then have 60-day cooling off period after the baby is born to decide whether she's keeping the child. If this option is not something the intended parents want to follow, it's also possible to make use of donor eggs or donor sperm. It's not possible to have both. In terms of our Act, it's important that at least two of the two intended parents' material needs to be used. The best interest of the child is here important. So it's important if it's a traditional surrogacy where the surrogate is using her own material. If she has a very close relationship with the intended parents, argument's sake it's her sister or it's her cousin, the court may see this as a potential problem and a pitfall, as she will have contact with the child during the child's life, and the best interest of the child is here at stake, meaning that the child may have a confusing situation with regards to who is the real mother. So this is something that will also be addressed with an evaluation by a clinical psychologist, and we usually advise clients as well that if it is a situation where traditional surrogacy is used and it's somebody close to the family, that they should rather than use donor eggs instead of traditional surrogacy. So in terms of the Surrogacy Act, it's very clear as to how the surrogacy application should take place. A lot of requirements that we have to meet beforehand. The surrogacy agreement will conform with all the requirements that we will also discuss with our clients, and then also discuss the process and the application as well, and the affidavits of the parties. If the surrogate is engaged or she's a life partner or she's married, that person will also form part of the application. The application needs to be lodged in the area where the intended parents are residing. So it's possible that you have the surrogate, argument's sake, in a different province and the intended parents in another province. We work with surrogacy countrywide and also internationally. Another issue that I would like to discuss shortly is the issue of domicile. In terms of our Surrogacy Act, it's important to establish whether the intended parents have the intention to reside in the jurisdiction of South Africa. So this means it's possible that we have non-South African citizens residing in South Africa, filed for permanent residency, have their own business in South Africa, and they've got the intention to stay here. They actually settled here, and it's possible to convince court that over a long period they've actually established themselves and their domicile, it's a legal term, in South Africa. It's not possible to move the domicile, that intention, in a short time period. This happens over a time period. So it's possible to have more than one property in different countries, but you will always have one place which is your main place of residence. It's possible as well for South Africans residing elsewhere in America or in England for a time period to lodge such application, and we've done this before, to lodge such an application and convince court that they will indeed return to South Africa and that this South African courts have your jurisdiction and that such a court order will be binding. I see we've got a question here. Orida is asking the approximate cost for such a process. So what is important here, Arlida, is to find out what the medical condition is of the intended parents. It may mean that there's more than one procedure that needs to take place. So first of all, the medical expenses needs to be discussed with a fertility doctor. Sometimes you make use of frozen embryos or donor eggs or donor sperm. There may be other possibilities as well, variables. So the expenses needs to be quoted by the fertility doctor, and bear in mind that those costs, the fertility treatment, will not be covered by medical aid. So you can discuss that with one of the fertility doctors. The cost pertaining to the surrogate herself depends whether it's a friend of yours, whether she's going to work throughout the surrogacy process. If she takes maternity leave and she really has a loss of income, argument's sake, for the last month or 2 months, it's possible that you can compensate her for that. So it's also variable, depends whether she's working for a salary at that stage and what the salary is, and then real out-of-pocket expenses. That's now traveling to the doctors, her medical aid, her portion of the medical aid, life coverage, and then, you know, any clothes, maternity wear that she needs. I hope that answers your question. And then the legal costs, it's possible to obtain a quote. It varies from attorney to attorney. We've got another question from Natasha. Once the application is approved, that document, how long is it valid for? Once a baby is born, does a surrogate... I can't see the rest of your mesh. Once a baby is born, does the document stay valid for the child's life? Natasha, how this works is in terms of the Act, the intended parents have an 18-month period in which they've got 3 attempts. So in that 18 months period, 3 attempts of IVF, and then the court order is granted, which means from the time baby is born, baby will be the rightful, or the parents, intended parents, will be the rightful parents of such child. Yes, so it's binding. That child will also be registered on the birth certificate of the child. Megan is asking, can you lodge an application where the intended parents are South African but the surrogate is locally internationally? Megan, this has happened before. We've handled matters like this in the past. The Act is saying that at the stage when the surrogacy agreement is signed, it should be signed in South Africa. It's quite important that the court take cognizance of the whereabouts of the surrogate. The court will definitely ask if it's argument's sake a sister of the intended parents and she's from an African country, that she's actually going to reside with them for the duration of the pregnancy and that the baby and her health is going to be safe. So it's possible to lodge an application where the surrogate is not necessarily a South African citizen, but that she resides in South Africa for the duration of the pregnancy. So the factual basis will determine what is possible, but yes, we can work with that. Natasha's asking again, once application is approved, that document, how long is it valid? We've discussed that. Thanks, Natasha. I see you've answered to that. So perhaps on compensation, while we're discussing the compensation of the surrogate, it's important that this should vary from month to month. It should not be a set amount per month. The court is quite strict. It's important that there should only be one agreement the parties sign. There can't be another additional agreement, which is a commercial agreement, to say you can't pay someone in cash or in kind. So once your sister's been your surrogate, you can't send her and her family on a trip overseas and say thank you. The Act is quite strict in this regard. So it's the court will ask for that, and then the costs for the out-of-pocket expenses that the intended parents will pay needs to vary. So it can't be 6,000 or 10,000 rand per month. It needs to vary as you purchase maternity wear and travel to the doctor, how often you travel to the doctor or have a nanny looking after your children. In months 1 and 3 and 4, it will be obviously less than later on seeing the doctor more often. If there are any more questions on surrogacy, you're more than welcome to send them through. I'm going to still handle 1 or 2 issues on surrogacy, and then we'll move on to the legal pitfalls on fertility agreements. Something else I would like to point out is the age with regards to the surrogate and the age of the intended parents as a possible pitfall. So it's important here that we should distinguish, as we've discussed initially, that the medical reason which is permanent and irreversible for intended parents to qualify for surrogacy, age of a woman does not qualify under this. So if somebody is, argument's sake, 55 years old or 50 years old, that in itself is not a qualification for surrogacy. If it means that the intended parent, argument's sake, the intended mother, lost her uterus and as a result of that she can't carry her own child, it's still possible to proceed even if it means that she's, argument's sake, in her late 40s. The surrogate mother needs to be fit, medically fit. The doctor, fertility doctor, will also look at her general health and her fertility, so that there's usually a mock cycle involved, that there's no wasted cost or time, that the surrogate struggles to fall pregnant after the court order is obtained. So the fertility doctor will take care of that. And then what is important here is we should distinguish here that genetic material of the intended parents is relevant with surrogacy. So if the surrogate, argument's sake, is 40 years old, and it's not her material that's going to be used for surrogacy, it's not relevant, or it's not a high risk as a woman that carries her own child being 40 and her genetic material is the age of 40. Argument's sake, we're working with frozen embryos, and the intended parents' material was frozen when they were 35 or 30 years old. That's the quality of the material that will be used. So it's possible still, if the surrogate is a bit older, she's 40 or 42 or 45, that the doctors will consider the best interests of the child and her general health status. We've got another question. Are there any platforms where parents can source potential surrogate mothers in South Africa? So what is important here, that's always the jackpot question, is where can we find a surrogate? In terms of our Surrogacy Act, it's not possible to advertise. You can't stick up your hand and say, I am looking for a surrogate mother, or a surrogate that's saying, listen, I will act as a surrogate mother. So we usually advise the intended parents to put the word out there in your circle of friends and with a fertility doctor, and to see if it's possible, somebody close to you, a friend, a cousin, a sister that can assist. There are really people out there that will act altruistically, that means really to assist you. There are surrogacy agencies in South Africa, international agencies as well. It's just important here to establish whether there was actually an assessment done. Some of these surrogacy agencies will just stick the details on their website, and there are no specific requirements that the people have to meet beforehand. It's important here that you should also realize that if you work with a surrogacy agency, you have to be able to provide an affidavit to court that no money was paid to the surrogacy agency. They can't charge you 10 or 20 or 50,000 rand for the exchange of information on a surrogate mother. So it's important. There's quite relevant information on this on our website, www.surrogacyagreements.co.za, with regards to agencies and all of that. I hope that answered that question. So it's possible to work with fertility clinics, to find out in your circle of friends, put out the word there, and really find someone that can assist you and does not do this as a source of income. We're going to move on now to the legal pitfalls with fertility agreements. So sometimes these agreements are part of surrogacy as well. Perhaps I should first point out what we're referring to. First of all, we get known and unknown donors. A known donor for eggs, or a known donor for sperm, or sometimes even known donors of an embryo. So there are different requirements. First of all, if it's an unknown donor, it's usually somebody that will go to a fertility clinic or to a specific sperm bank or egg donor agency and donate their material. There's compensation, but it's limited compensation in terms of the act. It's really to compensate someone for, the time that they've spent being out of office or traveling. It's limited. So there will be an agreement that the donor, we're referring now first of all to the unknown donors, unknown sperm, unknown eggs, at the fertility clinic, where they relinquish all their rights. So they move on, and there's no rights and responsibilities in time to come, or any legal claims from any offspring in that regard. So we have the Children's Act, and we've got the National Health Act that address all the different legal requirements. If you're working with a known donor, it's somebody that's identity is known to the recipient or the recipient couple. Now, in terms of our act, a recipient is usually a female person. So what is important here is if it's a known donor, known sperm donor, known egg donor, known embryo donor, is to have a discussion, consultation, and obtain advice with a fertility legal specialist in this field to draw up such an agreement beforehand, so that the donors also know where they stand with regards to their identity and also their involvement of any sorts and limitations of rights and responsibilities. I see there's another question here. What happens if the surrogate mother doesn't want to hand the baby over? Okay, we're quickly going to jump back, on surrogacy. So how this works is that in terms of our act, we've got the act since April 2010. So from the moment that the order is granted, it's a court application, the specific order is granted to say any child or children born from such an agreement are the lawful children of the intended parents. So and there's obviously a clinical psychological assessment in terms of the act on the intended parents for different reasons than for the surrogate mother. So there's a continuous process right throughout. And then on the day that the baby is born, from the moment that the baby's separated from the surrogate mother's body, the baby is a legal child of the intended parents, and there's always arrangements, discussions beforehand with the fertility doctor, the hospital. The intended parents are usually present as well. It depends whether it's a normal birth or a C-section, whether the intended, or rather the surrogate mother books in thereafter in the surgery ward, and for the intended mother to then be with a baby that's born. So it's a regulated environment, but if something like that still happens, which with the Act it's quite clear and very controlled, it's still possible then to obtain, or rather approach court on an urgent basis to assist. But there is a court order, so there is certainty. I hope that answers that question on surrogacy. We're moving back to fertility agreements. So we discussed known and unknown donors. First of all, unknown, so they sign the document at the fertility clinic and they move on, and then you have a recipient couple. It's quite a specialist environment and process from the fertility clinic side to match up and to make sure the requirements are met. There's usually a social worker involved with regards to the pairing and the expectations of the recipient couple. But what is important here, if I can point out a few things, is the marital status. The marital status of a donor. So we get this often, that somebody will say, knock on our door and say, can you assist us? I'm single and I've got a friend and I want this friend, argument's sake, the person that's knocking on our doors is female. I've got a friend, he's a male, and I want him to donate his sperm. I want a baby. And often we see that the donor is involved in a relationship, or the donor is involved in a marriage, or the donor is busy with a divorce that's been dragging on for a couple of years, but they actually want to donate. So the Act is very clear in this regard. We've got different acts, the Children's Act, the National Health Act, that if the donor is involved with someone, that person should also provide consent. That's important. So it's difficult if the person is not divorced yet to proceed with such a donation and for the fertility clinic actually to proceed with fertility treatment and to have a baby, from such a donor before that person is through with a divorce. So marital status is important here. And then what is important as well is once you've been through the process, whether it's a couple or a single person, storing genetic material at a fertility clinic, it's important that you have to declare your will. What happens to that material if you pass on or you disabled? Some people store their material for other reasons. Oncofertility, it's an oncology patient, and then later on somebody wants to make use, argument's sake, the life partner wants to make use of the material. If it's not addressed in the documentation at the fertility clinic, it's going to be problematic. So make sure that you address this issue beforehand. There's another question here. Lots of laws, but I can see why it's so important. Yes, indeed. Let me just see if I've answered this one. What happens if the surrogate mother... Okay, we've handled that one as well. So something else to consider here, because we must realize with surrogacy, you may sit with a donor, a sperm donor or an egg donor, known or unknown. So these other requirements that we're discussing on the donor agreement is quite important. So there's going to be an agreement between the donor and the fertility clinic, but also an agreement between the the recipient couple and the donor, and if the donor is in a relationship, that person forms part of such an agreement. Something else to consider is the identity of a known donor. So the best interest of the child is here again important, whether the identity of the donor is ever going to be disclosed to the child or to the closest family, and whether this information should be protected. There's also a specific section in the Act that makes provision for it. Another question here. If it's a boyfriend or a girlfriend donating, should consent be sought by the boyfriend, girlfriend? Yes, indeed. So what is important here? The question first of all is, if somebody wants to donate and there's a boyfriend or girlfriend, we first have to establish whether it's a long-standing relationship. We've actually assisted people now recently from a different country, and we had to establish whether it's a long-standing relationship or not. Is it possible for that person to actually say, but I was actually part of this person's life and the legal requirements were not met. So it's a process to establish how involved this girlfriend or boyfriend is, and whether it's a cohabitation relationship, whether it's established relationship, and whether certain rights have already vested in such a party. Back to the identity then is to discuss whether such identity is going to be an open fact, which is not preferable. If it's usually to closest friends and family, to have that also in agreement, and then also to discuss guardianship, so that if something happens to the recipient couple and they pass on, where will such child go? Even with surrogacy, to go one step back, with a surrogacy agreement and court application, there will also be guardians appointed. The court will also always act in such a child's best interest, to know that if child is not born yet and the intended parents pass on, where does such a child go? To know that such child has been taken care of financially as well, that there are life coverage in place, and even for the surrogate mother and for her family if something happens and she has a complication. It's also important, we're almost done, as we've discussed earlier, the involvement with the donor in the child's life, so that the expectations have to be discussed beforehand with the evaluation, how such person is going to form part of the child's life or not at all. Because if there's certain rights and responsibilities, which happens, you get somebody that's a known sperm donor, he wants to donate his sperm, but he doesn't want to be involved. He does not want to have any liabilities towards the child. That the recipient, the female that's receiving such the genetic material, should discuss this beforehand with the donor, and we should also cover that in the agreement. There's another question. There could be friends not wanting their girlfriend, boyfriend to know they are donating material. My experience so far. Yes, indeed, this is possible, but we should realize that this requirement is really where the fertility clinics should conform. There are certain protocols they have to follow, very strict regulations though, in terms of the National Health Act, so they cannot perform such a procedure without following it. And then if it's marginal, where the donor do not want the boyfriend or girlfriend to know, then the fertility clinic will not proceed. Thank you so much. So it's important here to summarize, if you don't have material that you store with the fertility clinic, to address the issue with incapacity, or if you're passing on, what should happen to the material. Because if your partner wants to make use of it and it's not addressed, it's not possible for him or her to make use of it. And then with surrogacy, it's possible for you to visit our surrogacy website, also with the fertility agreements. And if you've got any more questions, you're welcome to send us an email on Adele, ADELE, at A for Apple, V for Victor, D for Donkey, W for Water, .co.za. Adele at avdw.co.za. Thank you so much. Goodbye.